morning, ladies and gentlemen, esteemed guests, colleagues, and dear friends. It is with great honor and deep appreciation that I extend a warm welcome to our distinguished guests who have graced this occasion with their esteemed presence. We are privileged to have amongst us the Honorable Justice Ujjal Bhuyan, Judge of the Supreme Court of India, and our esteemed Chief Guest, the Honorable Mr. Justice Alok Aradhe, Chief Justice of Bombay High Court, our revered guest of honor, the Honorable Mrs. Justice Revati Mohite Dere, Judge of Bombay High Court, the Honorable Mr. Justice Mahesh Sharat Chandra Sonak, Judge of Bombay High Court, the Honorable Dr. Biren Sharaf, Advocate General of the State of Maharashtra. It is my distinct honor and privilege to welcome you all to this momentous occasion of the book release of the second edition of Treatise on PMLA, Law and Practice, authored by Advocate Akhilesh Dubey. To commence this auspicious occasion, let us invoke the light of wisdom and knowledge by lighting the ceremonial lamp. I kindly invite honorable dignitaries on the stage to proceed with the lamp lighting ceremony. Thank you. Before we begin with the proceedings for the day, let us take a moment to honor our esteemed guests who have made this occasion truly special. I request the host of the event, Mr. Ravi Puliani and Mahesh Puliani, the director of Bharat Law House, the publisher of the book, to present the memento and to felicitate the chief guest for today's event, the Honorable Justice Ujjal Bhuyan, Judge of the Honorable Supreme Court of India. We are also glad to inform that our chief guest is accompanied by his family. It gives us immense pleasure to welcome Mrs. Sangamitra Das Bhuyan. I would request Advocate Upasana Pandey and Advocate Rani Tripathi to felicitate ma'am. I would now request Advocate Prashant Relekar, President of Advocate Association of Western India, and Advocate Suresh Sabrat, Secretary of the Advocate Association of Western India, to present a memento and felicitate our guest of honor, the Honorable Justice Alok Aradhe, the Chief Justice of High Court of Bombay. I request Advocate Neha Bide, Government Pleader, and Advocate Shruti Vyas, Additional Government Pleader, to present a memento and to felicitate our special invitee, Honorable Mrs. Revati Mohite Dere, Judge of the Bombay High Court. I now request Senior Advocate Narendra Valavalkar and Advocate Rui Rodriguez sir, to present a memento and to felicitate our special invitee, Honorable Mr. Mahesh Sharat Chandra Sonak, Judge of Bombay High Court. I request Advocate Rakesh Bhatkar, Treasurer of Advocate Association of Western India, and Advocate Ashutosh Kulkarni to present a memento and to felicitate our special invitee, Honorable Dr. Biren Sharaf, Advocate General of Maharashtra. Ladies and gentlemen, we are deeply honored to welcome you all to this momentous occasion, the release of the second edition of book Treatise on PMLA, Law and Practice. This book is not just a compilation of law and regulations, but a comprehensive guide that sheds light on the intricacies of the PMLA 2002. The PMLA 2002 is a significant piece of legislation aimed at combating money laundering in India. It represents our nation's commitment to maintaining financial integrity and transparency. However, the complexities of the Act and its implications are often challenging to navigate. This book aims to bridge the gap, providing clarity and insights in the Act's various aspects. The book is authored by Mr. Akhilesh Dubey, Advocate and Solicitor, who has meticulously researched and authored this book, ensuring it is both comprehensive and intellectually accessible. It serves as a valuable resource for legal professionals, students, and anyone interested in understanding the PMLA 2002. As we unveil this book today, we hope it will serve as a beacon guiding those who seek to understand and navigate the complexities of the PMLA 2002. Thank you all for being a part of this significant event. Your presence here today underscores the importance of continuous learning and the pursuit of knowledge in our ever-evolving landscape, and your presence underscores the importance of knowledge in life, which can be summed up in the shloka from Bhagavad Gita. Vidya dadhadi vinayam, vinayad yati patratam, patratvat dhanma protit, dhanat dharma tatah sukham, which translate as, knowledge bestows humility, humility leads to worthiness, and worthiness earns wealth, which paves the way to righteousness and happiness. Let's celebrate the release of this remarkable book, a testament to the power of knowledge and the importance of understanding the law that governs us. Thank you. May I request the honorable dignitaries on the dais to release the book. I call upon Ravi Puliani and Mahesh Puliani, the publisher of the book, on stage. I am now honored to introduce our special invitee, the Honorable Dr. Biren Sharaf, Advocate General of Maharashtra. Dr. Sharaf pursued his legal education at the Government Law College, Mumbai, and later completed his PhD on judicial intervention in arbitration in India, with over 27 years of practice at the Bombay High Court. And Dr. Sharaf was designated as a senior advocate in 2020 and subsequently appointed as an Advocate General of Maharashtra in December 2020. While Dr. Sharaf has graciously requested not to speak much as he has traveled from especially to attend this event, we would be deeply honored if he could share just a few words with us to remark this memorable moment. Dr. Sharaf's insights, however brief, will undoubtedly enrich the significance of this event. I request Dr. Sharaf, the Advocate General of the state of Maharashtra, to say a few words to grace the event.
Honorable Justice Ujjal Bhuyan, sir. Honorable Chief Justice Shri Alok, Aradhe, Justice Dere, Justice Sonak, learned judges of the Bombay High Court, learned senior advocates present, the Registrar General of the Bombay High Court, my fellow lawyers, ladies and gentlemen. There is a galaxy of illustrious people who are going to speak today, who are extremely knowledgeable in the field. And therefore, my request to Akhilesh that I should not be asked to speak was less from the perspective of I traveling this morning and more from the perspective of not exposing my own ignorance. But they've asked me to speak, so I'll speak for a few moments. Before I start, the learned Additional Solicitor General has asked me to convey his apology to all of you. He's down with high fever and therefore he could not attend today's event. I really congratulate Mr. Akhilesh Dubey today for the release of the second edition of his book. Just some time back, we all met for the release of his book's first edition. And the fact that the second edition of the book has come out within such a short time is really a testimony of how well appreciated his book was and the need for a second edition. So congratulations, and I'm sure the entire legal fraternity will be benefited by your research and scholarly work. I had just joined the bar as a junior, and I was sitting in the library, and I asked for something, some law on some subject. And the librarian, a seasoned librarian of the library, got me some book. And I told him that, Jairam, this law has changed. So he looked at me and said, the law does not change, the law evolves. So that was the first lesson I learned from a librarian in the High Court library. And the pace with which the law relating to economic offenses particularly is evolving requires regular updating of the law. Very often, just 2 years later, you wonder that is this the same law that we are reading that we were reading 1 year back? There is so much of evolution, there is so much of change in the thought process of the entire jurisprudence on this subject. And therefore, there is a constant need for some academic scholarly research on the subject, which notices the change in the thinking process of the judges of what has led to this evolution. And in this process, a lawyer's thought is of great importance, because a lawyer's perspective is not just an academic perspective. A lawyer's perspective mixes the academic position, the bare reading of the text, the thought process of the learned judges while delivering the judgment, as well as the practical realities which the people on the field face. And that knowledge of the practical realities, the practical difficulties, and the evolution of the law, how it affects its practical application, is a perspective which, when a lawyer puts in a research work, really goes a long way in the development and evolution of law. And it's not easy for a practicing lawyer to find time to do this. So I would really congratulate Mr. Dubey in the midst of his thriving practice to find time to pursue his academic interests. And this book will surely help the legal fraternity in the better understanding of the law, and it will, of course, help in the development of the law on this subject. So with this, I'll not take much time. Thank you very much for inviting me. Thank you.
Thank you so much, Dr. Sharaf. Now, our next guest is Honorable Justice Mahesh Sharat Chandra Sonak. Honorable Justice Sonak completed his law from MS Law College, Panji, Goa, in first class, and he has completed his diploma in Portuguese language awarded by Xavier Center of Historical Research, and enrolled as an advocate on the rolls of Bar Council of Maharashtra and Goa in October 1988. Justice Sonak practiced at Panji bench of the Bombay High Court in civil and constitutional law, and also has his expertise in labor and service law, environmental law, commercial and tax laws as well. Additional standing counsel for central government, special counsel for state government and statutory corporations. Justice Sonak was elevated as an additional judge of the High Court of Judicature at Bombay on 21st of June 2013. May I kindly invite Mr. Justice Mahesh Sharat Chandra Sonak to share his insights and enrich this event with his esteemed words.
Thank you. Honorable Justice Bhuyan, our Chief Justice, Justice Alok, Aradhe, Sister Revati, Advocate General Biren Saraf, my sisters and brothers in the audience and of the days, distinguished senior advocates, ladies and gentlemen, and of course, above all, the person who has made this occasion possible, the author of today's book, Mr. Dubey. Heartiest congratulations to Mr. Dubey. Friends, I had not come prepared to either sit on the dais or to give a talk. And in that sense, I think you all are fortunate, because if I were to come prepared, I would have unnecessarily taken a lot of your time. We have a galaxy of speakers, and we are all extremely eager to hear them. And please include me in that eager audience. I have also not had the occasion to read the first edition of Mr. Dubey's book, and the second edition is just out. But I had the good fortune of just hurriedly going through the wonderful forewords by Justice Gavai and my dear friend Justice Karnik. They have paid rich tributes to the author and his writing, and I'm sure that these tributes are well deserved. They have emphasized that this complex subject has been explained by Mr. Dubey in simple words. And friends, let me assure you that when a subject has been expressed in simple terms, be sure that a lot of hard work and effort has gone into that kind of a presentation. We are very grateful to Mr. Dubey. We are very grateful to the publishers. We are also very grateful to Justice Bhuyan. I think the Advocate General spoke about the evolution of law. Between the first edition and the second edition, the most significant contribution to the evolution of this law has been by Justice Bhuyan and Justice Oak to this subject. And we are extremely fortunate that Justice Bhuyan is here for this function today. So again, I thank you all for giving me this honor. I thank Mr. Dubey for making this occasion possible. And thank you very much for bearing up with me. Thank you.
Thank you, sir. Our next guest is Honorable Mrs. Justice Revati Mohite Dere. Honorable Mrs. Justice Revati Mohite Dere, after completing her LLM, joined the chambers of her father, eminent senior advocate Vijay Rao Mohite at Pune, and thereafter the chambers of Barrister Raja Bhosle in Mumbai. Our Honorable Justice Dere practiced in the High Court of Bombay on the criminal, civil, and constitutional side, and also in the Sessions Court. Justice Dere was appointed as an additional judge of the Bombay High Court on 21st of June 2013 and elevated as a judge of the Bombay High Court on 2nd March 2016. Justice Dere has made remarkable contributions to the field of law, particularly in upholding police accountability, addressing corruption, and advocating for women's rights. Her landmark judgment in Ram Kutumal Israni versus Directorate of Enforcement set a significant precedent in promoting fundamental rights and ensuring the procedural fairness under the PMLA. Justice Dere's work exemplifies judicial excellence, balancing legal acumen with a deep sense of justice and human rights. May I kindly invite Mrs. Justice Revati Mohite Dere to share her insights and enrich this event with her esteemed words.
Honorable Justice Bhuyan, the Chief Justice of the Bombay High Court, Shri Alok Aradhe, my colleague Justice Sonak, the Advocate General, Dr. Saraf, my esteemed colleagues who are present here today, senior advocates, law students, Mr. Akhilesh Dubey, the publishers, ladies and gentlemen. We have all gathered here today for the book release of the second edition on Treatise on PMLA, a book which is a labor of passion and hard work of Mr. Dubey. It is indeed commendable that Mr. Dubey has come with the second edition within a short span of one and a half, 2 years of the first edition, considering the recent and rapid developments on this law on this subject. This book is a result of meticulous and in-depth research and careful analysis, making it an invaluable resource for legal professionals, academicians, law enforcement agencies, law students, and all interested in understanding the intricacies of the PMLA. The power of knowledge and the importance of staying informed about the laws that govern our society lie in their ability to empower individuals and promote justice. There are very limited commentaries available under the PMLA Act, and I'm confident that this book will be a great source of reference for one and all. My first encounter with the PMLA was in 2011-2012, when I was representing the Enforcement Directorate in Hassan Ali's case. I appeared in the Sessions Court with Mr. Nikam, in the High Court with the then ASG, and again in the Supreme Court with the then ASG. There were no judgments to fall back on, and much less books. In fact, there were hardly any reported cases also on PMLA. One issue that was raised, which was of importance in that particular case, was whether money transactions that had taken place prior to the coming into force of the PMLA Act in 2005 could be considered or taken into account. It was all about how money circulates, how it is layered, and how it is brought back into the system. And of course, we had to do a lot of research, and how it would apply was the decision eventually. The PMLA came into effect on 1st July 2005. It was amended several times in 2005, 2009, 2012, 2019, 2022, and 2023. But the most significant amendment that took place was in 2019. These amendments introduced new concepts and made changes in existing provision. While these amendments are aimed to strengthen the PMLA and to make it more effective in curbing money laundering and to provide for confiscation of property derived from or involved in money laundering, these amendments also raised several new issues and challenges vis-a-vis its interpretation. Although in Vijay Madan Lal Chaudhary versus Union of India, the Supreme Court stressed upon the judicial principle that the provisions of PMLA must be interpreted in a manner that balances enforcement with individual rights, the same was not followed in its true letter and spirit. In the past year, the Apex Court has delivered several landmark and significant judgments, further clarifying and interpreting various provisions of the PMLA, ensuring that its stringent provisions do not violate fundamental rights which are enshrined in the Constitution. Notably, in Prem Prakash versus Enforcement Directorate, the Supreme Court underscored that while Section 45 of the PMLA imposes twin conditions for granting bail, it does not override the constitutional mandate of personal liberty enshrined under Article 21 of the Constitution. In the recent judgments, the Supreme Court has realigned the interpretation of the provisions of PMLA with broader jurisprudence that pre-trial detention should not be used as a punitive measure. The Supreme Court has also revisited the issue pertaining to rights of the arrested persons in Pankaj Bansal's case. It held that an accused must be informed of the grounds of his arrest under Section 19 of the PMLA. The judgment in Pankaj Bansal illustrates how the Constitutional Court has struck a balance between the mandate of Article 22.1 of the Constitution and Section 19.1 of the PMLA. Another legal issue which is under consideration before the Supreme Court is the need and the necessity to arrest an accused when the accused has cooperated with the investigation. In Arvind Kejriwal's case, the Supreme Court addressed the issue whether the need and necessity to arrest can serve as an independent ground to challenge the arrest under Section 19.1 of the PMLA. The matter has now been referred to the larger bench for consideration and is pending. But this was the first instance when the Supreme Court acknowledged the Enforcement Directorate's obligation to substantiate the need and necessity of arrest by providing documented reasons justifying such action. In Pankaj Bansal again, the Supreme Court held that mere non-cooperation of a witness in response to a summons issued under Section 50 of the PMLA is not sufficient to render them liable to be arrested under Section 19 of the PMLA. It further held that the investigating officer must have reason to believe that a person is guilty of an offense under the PMLA and that mere evasiveness or non-cooperation in providing information is not enough to meet this threshold. Again, in Tarsim Lal's case, the Supreme Court addressed a pivotal issue by limiting the Directorate's authority to arrest an individual under Section 19 of the PMLA, once the special court had taken cognizance of a complaint filed under Section 44. The court held that Enforcement Directorate cannot arrest an accused after the special court has taken cognizance of a case. Of course, under Section 19, we now know what are the principles with respect to an arrest of an accused, which starts from the reason to believe, which has to be shown that the person is guilty of an offense punishable under PMLA, and that belief must be based on material evidence in the officer's possession. Second, the reasons to believe must be recorded in writing before arresting the accused. Third, the written grounds of arrest must be furnished to the accused as a matter of course and without exception, the object being to give meaning and purpose to the constitutional mandate and the statutory mandate under Section 19 of the PMLA. Fourth, the grounds of arrest must be communicated to the arrested person as soon as may be. Fifth, mere possession of incriminating material is not sufficient, that there must be a justifiable need to arrest at that particular time, which means essentially whether there is necessity to arrest. And last, that an arrested accused must be produced before the special court within 24 hours. Thus, non-compliance of any of this would inure to the benefit of the accused for non-compliance and give the accused the benefit. All these judgments that I just mentioned and several others passed in the last 1 or 2 years are a testament of the commitment of the constitutional courts to ensure that executive actions do not violate constitutional mandates. And let me tell you, most of the judgments are of the division bench of Justice Bhuyan and Justice Oak, and therefore no better person than to speak on this topic today, on this occasion. Another very interesting case, which I must tell all of you, which came before us when I was sitting in division bench with Justice Manjusha Deshpande. The question in that case was whether the statement which is recorded of the person who is summoned under Section 50 of the PMLA Act can be recorded so late in the night. In that particular case, the person, the petitioner, was summoned under Section 50, had already attended the summons on 3 occasions. He was summoned on a particular date for recording of his statement under Section 50. He went at 10 o'clock in the morning, but his statement commenced, the officer started recording his statement at 10:30 in the night and continued till 3:30 in the morning, and he was arrested at 5:30 and brought. Although the petition before us was for a declaration that his arrest was illegal and that even the remand order should be quashed, we found no merit in that because he was produced within 24 hours before the special court. But what we observed and we deprecated was the practice of keeping somebody so late in the night and for recording of the statement. In that particular judgment, we have said that the right to sleep is a basic human right, and no person can be deprived of the same. The cognitive skills at that point of time, because of lack of sleep, impairs the person's ability to say what he would want to say. So we thought, although we had dismissed the petition, we directed the Enforcement Directorate to come up with guidelines, because ultimately enforcement officers, directorate officers, are not police officers. So we asked them to come up, frame certain guidelines that the statements will not be recorded post office hours, and it has to be recorded in a reasonable time frame when the office is working. And I must tell you that this order was taken in the right spirit by the Enforcement Directorate, and they issued guidelines where they have, which have now been put up on their website, which state that they have to record the statement within early hours and not like what was done in the particular case. So these are the kind of cases, and with Justice Bhuyan and Justice Oak and Justice Gavai and all other judges there, I'm sure the author will have to keep that in mind, and the 3rd edition will have to be again updated, and again maybe after a year or 2. Today, we have Justice Bhuyan, as I said, who has dealt with the many landmark cases, and I'm also as eager to hear him as you all are. I once again take this opportunity to congratulate the author, Mr. Dubey, and the publishers for coming up with this book. Thank you for inviting me.
Thank you, ma'am. Our guest of honor, the Honorable Chief Justice, Shri Alok Aradhe. Honorable Justice Alok Aradhe, the 48th Chief Justice of the Bombay High Court, is a highly respected figure in the Indian judiciary, born on 13th of April 1964. Honorable Chief Justice studied BSc and LLB and enrolled as an advocate on 12th of July 1988. Honorable Chief Justice has practiced civil, constitutional, arbitration, and company matters in the High Court of Madhya Pradesh. Honorable Chief Justice was designated as a senior advocate in April 2007. The Honorable Chief Justice contributed significantly to legal literature by revising the 5th and the 6th editions of the Principles of Administrative Law by MP Jain and SN Jain. and the 15th edition of the Principles of Statutory Interpretation by late Honorable Justice G.P. Singh, former Chief Justice of India of Madhya Pradesh. The Honorable Justice Aradhe was appointed as an additional judge of the High Court of Madhya Pradesh on 29th of December 2009 and became a permanent judge on 15th February 2011. I would now request our Honorable Chief Justice Shri Alok Aradhe to say a few words to grace this occasion.
Honorable Mr. Justice Ujjal Bhuyan, Judge Supreme Court of India, Mrs. Justice Revati Mohite Dere, Justice Mahesh Sonak, my esteemed colleagues on the bench, Dr. Biren Saraf, Advocate General for the State of Maharashtra, Mr. Akhilesh S. Dubey, author of the book, esteemed senior advocates and learned members of the bar, distinguished guests, ladies and gentlemen, a very good morning to all of you. It's indeed my privilege to witness the release of the book authored by Mr. Akhilesh S. Dubey, Advocate on Prevention of Money-Laundering Act 2002. I extend my heartiest congratulations to the author for this commendable contribution to the field of legal literature. As an author, I understand the dedication, perseverance, and passion that goes to creating a work of this nature. The book comes at a crucial time when the legal and financial landscape is increasingly grappling with the complexities of money laundering and its far-reaching consequences. The PMLA Act was enacted to combat the menace of money laundering and to ensure that proceeds of crime do not infiltrate the legitimate financial system. Over the years, this law has undergone significant amendments, expanding its scope and strengthening enforcement mechanisms. The jurisprudence around PMLA has also evolved, with courts playing a pivotal role in interpreting its provision in the light of constitutional principles, due process, and global obligations under Financial Action Task Force guidelines. A work such as this, which comprehensively analyzes the law, its procedural aspects, and its practical implications, is invaluable not only to legal practitioners, but also to the enforcement agencies, policy makers, and scholars. The author's meticulous research, case law analysis, and practical insights will undoubtedly serve as a guiding light in navigating the complexities of anti-money laundering regulations. The second edition is not merely a reprint, it is a timely and much needed response to the evolving nature of PMLA Act and its growing complexity. The challenge before us as members of the legal fraternity is to strike a balance between stringent enforcement and protection of fundamental rights. Money laundering is not merely an economic offense. It has implications for national security, financial stability, and public trust. I am sure that this book shall be useful to its readers like the previous edition. I am equally eager to hear Justice Bhuyan, and I've been told that it's his favorite topic. So I will not stand between you and him. And once again, I congratulate Mr. Dubey and wish him great success in future endeavors. Thank you.
Thank you, sir. The chief guest of today's afternoon is Honorable Justice Shri Ujjal Bhuyan. Honorable Justice Ujjal Bhuyan, a distinguished judge of the Supreme Court of India, has had an illustrious career in the field of law and justice. Born on 2nd August 1964 in Guwahati, he embarked on his legal journey in the year 1991 after obtaining his LLB degree from the Government Law College, Guwahati, and LLM degree from the Guwahati University. Justice Ujjal Bhuyan has carved an illustrious path in the field of law and justice. Honorable Justice Bhuyan, through his judgments, has always protected the rights of the life and the liberty enshrined in the Constitution of India. Justice Ujjal Bhuyan has made a significant contribution to the jurisprudence surrounding the Prevention of Money-Laundering Act, emphasizing the balance between the effective law enforcement and the protection of the constitutional rights. His judgments and observations have consistently advocated for transparency, restraint, and adherence to procedural safeguard under the PMLA. Notably, he has cautioned against the misuse of the Act, stressing that overreach by authorities could harm public trust and infringe upon fundamental rights guaranteed under Article 21 of the Constitution of India. Justice Bhuyan has also reinforced the importance of judicial scrutiny in cases involving stringent laws like PMLA to ensure the innocent individuals are not wrongfully targeted. His landmark rulings, including limiting the Enforcement Directorate's power, post-cognizance, and advocating for the fair trial principles, underscores his commitment to upholding personal liberty while ensuring accountability in combating financial crimes. Through his thoughtful interventions, Justice Bhuyan has enriched the PMLA jurisprudence, setting a precedence for balancing enforcement and constitutional values. With his vast experience, knowledge, and commitment to the justice, we hope he continues to inspire and uphold the values of the Indian judiciary. We express gratitude and thank him to grace the stage during his busy schedule. I request Honorable Justice Bhuyan to say a few words to grace this occasion.
Justice Alok Aradhe, Chief Justice of the High Court of Bombay, Justice Dere, Justice Sonak, Learned Advocate General, my esteemed sister and brother judges of the Bombay High Court, the spouses who are present here, the Vice Chancellor of Maharashtra National Law University, Mumbai, Registrar General and Registrars of the Bombay High Court, the star of today's program, the learned author, advocate and solicitor Shri Akhilesh Dubey, publisher, Bharat Law House, eminent senior advocates, members of the bar, distinguished guests, my dear students, ladies and gentlemen, a very good morning to all of you. It's a nice feeling to be back in Mumbai. In fact, rekindling our fond memories of our stay here. And during the COVID period, when we had a lot of spare time, one student ambassador representing SCC online, she said, whether, sir, can I have an interaction with you? No, of course, why not? So one of the questions she put to me was how I felt to be in the Bombay High Court. I remember, I said many things, but I remember to have told her that the bar in Bombay is excellent. And they had warmly received me from day one. Regarding my colleagues, quite a few of them have retired in the meanwhile. I had said that from day one, I never felt that I was in a different high court. All of them were very kind and generous to me and to my family. And at Vidhi, we were all like a family. When we suffered a COVID attack, help came from all corners. This feeling of oneness has made us emotionally attached to the Bombay High Court. So much so that before leaving for Hyderabad, we decided to opt for the membership of the Survi Housing Society. So therefore, I'm very happy to be back here amidst my extended family. Justice Aradhe and myself, we share at least one thing in common. Both of us have traveled the length and breadth of the country in our judicial journey. While I came from the east to the west, from west to the south, south to the north, Justice Aradhe from MP High Court went to J&K High Court. From J&K, he went to Bangalore, from Bangalore to Hyderabad, and Hyderabad to Mumbai. We do not know the next leg of the journey, or the final leg of the journey. I remember I think it was last year, we were in Hyderabad in a tax conference. We shared the podium there, and today also we are here for this release of this book, the second edition. I was in NCPA, I think last year. Justice Makarand was there, Justice Patil was there, Justice Madhav J was there. On the occasion of release of the book, this treatise on PMLA, Law and Practice, authored by Akhilesh Dubey, I am told that the book has received an overwhelming response from the members of the bar and other stakeholders. Hence, the need for the next edition of the book, for which I am back here today. At the outset, I must congratulate Shri Dubey for authoring this extensive book on PMLA. This book, the fact that this book has been accepted by the reading public indicates that Shri Dubey has been successful in his endeavor. I also take this opportunity to compliment the publisher, Bharat Law House, for publishing the next edition of the book, Treatise on PMLA, Law and Practice. Last year I had said that law publishers remain invisible, but they are so much a part of the system that without law books, despite advent of technology, our chambers will not look like a chamber of a lawyer or that of a judge. So, howsoever technologically advanced we may be, law books are here to stay. Friends, before I say something about PMLA, I must put in a caveat. This Prevention of Money Laundering Act 2002 is still a live issue, as was last year. Cases under the PMLA are hotly contested. And for whatever reasons, many of such cases have acquired political overtones. Cases of PMLA are regularly listed before my bench. So therefore, besides being a sitting judge of the Supreme Court, I have my own limitations. So therefore, I will confine myself only to the text of the law and few of the decided cases. And I will not repeat what I had said last year. I'll take off from where I had left last year. It is not necessary for us to delve into the legislative history of PMLA. All that we need to know or keep in mind that PMLA, as was envisioned, it was envisioned as a robust mechanism to deter financial crimes and to ensure India's compliance with global anti-money laundering obligations. Now, to put the matter in perspective, we need to know what is money laundering, both in the popular parlance as well as the statutory definition of money laundering. I remember it was way back in 2016 when in the Assam Judicial Academy, the Director of Enforcement Directorate had come. The subject was very new at that point of time. And he described in his own way what is money laundering. And he said, just like we give our soiled clothes to the laundry, and after the clothes are cleaned, pressed, and presented like fresh clothes, money laundering is introducing crime-tainted money, going through the process of untainting and presented into the legitimate economy as clean money. This is, in simple words, money laundering. I think Justice Makaran in his foreword has also referred to this popular concept of money laundering. But if you go to the definition in the Act, it is defined in Section 3, which also makes it an offense. And Section 3 says that whoever is involved in any process or activity connected with proceeds of crime, including concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, is guilty of the offense of money laundering. So we can broadly say that a person would be guilty of the offense of money laundering if he is involved in any process or activity connected with the proceeds of crime and projecting it as untainted property. And since it is an offense, the punishment is provided in Section 4. Minimum is 3 years, maximum is 7 years, with fine also. Now, as you have seen, one of the important conditions is that to constitute the offense of money laundering, the person concerned must deal with various aspects, concealment, possession, etc., of proceeds of crime. So what is proceeds of crime next becomes very important. It is defined, it's a defined expression under the PMLA, and it means any property derived or obtained by any person as a result of criminal activity relating to a scheduled offense. So there is a schedule to the PMLA, and whoever is involved in any criminal activity relating to an offense as per the schedule and accrues income, those will be treated as proceeds of crime. The source must be of the scheduled offense. So in Pavana Dibur versus Directorate of Enforcement, Supreme Court observed that every crime which may generate proceeds of crime need not be a scheduled offense. Only certain specific offenses have been included in the schedule. It is not necessary that a person who is accused of an offense under Section 3 of PMLA must be shown as an accused in the scheduled offense. But if the accused shown in the complaint under the PMLA is not an accused in the scheduled offense, he will get the benefit of acquittal of the accused in the scheduled offense. He will also get the benefit of discharge or quashing of proceedings in the scheduled offense. So this is the substance in Pavana Dibur. Now, as you all know, those who are dealing with PMLA, broadly it can be classified into two categories. One is the civil aspect, dealing with attachment, provisional attachment, all those. And the other is arrest and criminal prosecution. I will also not deal with the case of Vijay Madan Lal Chaudhary, because I am part of the bench constituted by the Chief Justice of India to look into the question as to whether Vijay Madan Lal Chaudhary needs a revisit or a relook. So this matter is still alive. But we can safely say that Vijay Madan Lal Chaudhary had rejected all the challenge to various provisions of the PMLA, holding that all those provisions are constitutionally valid. But as I said, a bench has been constituted to look into whether this decision needs a revisit. In the light of the fact that there are various other provisions are there, particularly Section 50, whether statements recorded by the officers of the Enforcement Directorate, what is the evidentiary value of those statements? This needs to be gone into. And also the fact that, of course, this is not the remit of Vijay Madan Lal, that the amendment to the PMLA was brought in as a money bill. Whether amendment to PMLA could have at all been brought in as a money bill again is a live issue. The challenge is pending in the Supreme Court. So this aspect also, I will not go into it. Now, since money laundering is an offense, the natural corollary is of arrest and prosecution. And the Enforcement Directorate is the mandated authority to either arrest or to prosecute under Section 19. In Senthil Balaji, this is the first Senthil Balaji, Supreme Court declared that the authorized officer, while arresting a person, has to first assess and evaluate the materials in his possession and then form a reason to believe that such person is guilty of the offense of money laundering. Pausing here for a moment, this expression, reason to believe, is not a defined expression, but this is an expression which is used across statutes, be it revenue statutes or penal statutes. We need not go into Calcutta discount. Much water has flown since then, 1962. Sum and substance is that this expression means that there must be objective factors and there must be an objective analysis about the requirement of arrest. It cannot be a subjective satisfaction of the authority. So in this Senthil Balaji 1, Supreme Court held that the authorized officer, while arresting a person, must perform the mandatory duty of recording reasons, and they should be served upon the arrestee. This was followed and taken a step further in Pankaj Bansal, where the Supreme Court referred to the safeguards under Article 22(1) and held that the arrested person should be informed of the grounds of arrest. Written grounds of arrest should be furnished to the arrested person as a matter of course and without exception. In some cases, it was found that officers of the Enforcement Directorate used to, while at the time of arrest, used to read out the grounds of arrest and not furnish the arrestee the written grounds of arrest. So the court said that mere reading out the grounds of arrest is not adequate. Is not a full compliance of Article 22(1). And these are not compliances which are, these are mandatory compliances. Otherwise, the arrest would be in contravention to Article 21 and thus illegal. Now, in August 2023, one journalist in Delhi, Prabir Purkayastha, he was arrested under the Unlawful Activities Prevention Act, UAPA, 1967. So he challenged his preventive detention, his detention under the UAPA. So in this case, Prabir Purkayastha versus State, the bench of Justice Gawai and Justice Sandeep Mehta, they referred to Pankaj Bansal. And thereafter, they made an analysis, comparative study of Section 19 of PMLA, which is the power to arrest, and Section 43 capital A of UAPA, which is the power to arrest under the UAPA. And observe that there is no significant difference in the language employed in Section 19 of PMLA and 43A of UAPA. And thereafter, they applied the law laid down in Pankaj Bansal to the case of Prabir Purkastra, holding that the grounds of arrest has to be informed to the arrested person in writing, whether it is a case under PMLA or under UAPA. If the grounds of arrest are not communicated, the arrest would be illegal. Therefore, Prabir Purkastra was released on this ground itself. Next comes the case of Arvind Kejriwal. I am not talking about the second Arvind Kejriwal or my concurring judgment in Arvind Kejriwal versus CBI, but this is the case of Arvind Kejriwal versus ED. He had challenged, he did not apply for bail. He had challenged his arrest by the Directorate of Enforcement under Section 19 on the ground that the inbuilt safeguards provided under Section 19 were not complied with, and therefore the arrest itself is illegal. I need not go for bail. The bench held that power to arrest granted to the ED under Section 19 of PMLA is fenced with certain preconditions which act as stringent safeguards to protect the life and liberty of individuals. After observing that the power to arrest a person without a warrant and without instituting a criminal case is a drastic and extreme power, the bench held that the authorized officer must have material in his possession on the basis of which he must form an opinion and record it in writing the reasons to believe that the person arrested is guilty of an offense under the PMLA. The grounds of arrest are required to be informed to the person arrested forthwith. Now, ED had made a submission before the court that the reasons to believe being an internal and confidential document need not be furnished to the arrestee. But this was rejected by the bench. And Justice Khanna, who had authored the judgment, he said that reasons to believe are required to be furnished to the arrestee so that he can challenge the legality of his arrest before a competent forum. There is distinction between the reasons to arrest and the grounds for arrest. While the former refers to the formal parameters, the latter would require all such details in the hands of the authorized officer necessitating the arrest. Thus, the grounds of arrest would be personal to the accused. Arvind Kejriwal is also an authority for the proposition that courts can judicially review legality of arrest. The power of judicial review is inherent in Section 19 and is permissible both before and after criminal proceedings or prosecution complaints are filed. Thereafter, the bench referred it to a larger bench on a number of questions, 3 questions to be precise, including the question as to whether the need and necessity of arrest can be a ground, a separate ground of challenge to an order of arrest under Section 19. Now, in the second Kejriwal case, which arose out of his arrest by CBI while he was in ED custody, I had mentioned in my concurring opinion that the power to arrest is one thing, but the necessity to arrest is altogether another thing. In that case, I had recorded that there was no necessity for CBI to have made the arrest when the petitioner Kejriwal was not arrested for about 2 years since registration of FIR by the CBI. And when he was on the cusp of release in the ED case, he was arrested. Therefore, his arrest was declared as illegal. Now, whenever we talk about arrest and bail, it is necessary that we also deal with the rigors of Section 45 of PMLA. Now, PMLA 45 says that it is akin to 37 of the NDPS or 43D of UAPA, that no person accused of an offence under a PMLA shall be released on bail unless the public prosecutor is given an opportunity to oppose the bail. And if he opposes the bail, the court must be satisfied that there are reasonable grounds to believe that he is not guilty of such an offence and that he is not likely to commit any such offence while on bail. Indeed, these are very, very tough conditions. It is very difficult for a court to record such findings, that he will not commit any such offence while he is on bail. I don't think which court can record such a finding. Justice Dere had referred to the case of Prem Prakash versus Union of India, again authored by Justice Gavai. He said that despite the twin conditions, stringent conditions under 45 PMLA, the golden principle of bail is the rule and jail is the exception continues to hold good. Article 21 is a higher constitutional right, fundamental right, and therefore statutory provisions like 45 should align with the higher constitutional edict. This is the sum and substance of Prem Prakash. Now in Directorate of Enforcement versus Subhash Sharma, a bench of Justice Oak and myself, we held that once a court dealing with a bail application finds that fundamental rights of the accused under Articles 21 and 22 are violated, whether at the time of arrest or after arrest, it is the duty of the court dealing with the bail application to release the accused on bail. It is the duty of every court to uphold the fundamental rights under Articles 21 and 22. Therefore, when the arrest is illegal, bail cannot be denied on the ground of non-fulfillment of the twin conditions under Section 45 of PMLA. This is a further development of the law that if the arrest itself is illegal, we need not go into the aspect of the twin conditions under Section 45. Those will not be attracted. Now, an interesting question arose in Directorate of Enforcement versus Bibhu Prasad Acharya. In this case, a complaint was filed by the ED after investigation was over under Section 44, in which this Bibhu Prasad Acharya and one more person, they were shown as accused. Special court took cognizance and issued summons to all the accused persons, including these two. Acharya and the other person, they filed a writ petition in the High Court saying that we are public servants. And therefore, before cognizance was taken, the special court ought to have inquired into whether sanction under 197 CRPC was taken or not. The High Court accepted their contention and quashed the order of cognizance, qua the two accused persons. ED challenged this decision before the Supreme Court. Supreme Court held that Section 197(1) CRPC will apply to the provisions of PMLA and held that the view taken by the High Court is correct. So therefore, in case of public servants, if before filing a complaint under 44, it is necessary that sanction is taken under 197 CRPC. Of course, there are judgments which says that whether this is part of their official duty or not, whether sanctions should be taken. These are besides the point. The basic issue is, in case of a public servant, the requirement is that sanction is to be taken under 197. The next case is Tarsem Lal versus Enforcement Directorate. Now, in this case, Supreme Court held that once a complaint is filed under 44, it is like any other complaint. So therefore, sections 200 to 205 CRPC, I am not yet conversant with the corresponding provision of the BNSS. We will stick to the old format. 200 to 205 CRPC will apply. In many cases, what was happening was that, in many places, once a summons were served upon an accused, or in some cases warrant also, and when they reported back to the, responded to this summons or warrant before the special courts, they were taken into custody. And thereafter, they were required to satisfy the twin conditions of 45. So this aspect was gone into in Tarsem Lal. And Tarsem Lal says that when an accused appears pursuant to a summon, the special court shall not treat him as if he is in custody. It would not be necessary for him to apply for bail. The special court can direct the accused to furnish bond in terms of section 88 CRPC. But what is of utmost significance is that court has held, Supreme Court has held, that after cognizance is taken by the special court, the Enforcement Directorate is powerless to exercise power under section 19 to arrest a person shown as an accused in the complaint. If it still wants to arrest a person shown as an accused, not arrested, cognizance taken by the special court, then it has to apply to the special court. And the special court must afford an opportunity of hearing to the accused person and thereafter pass a reasoned order. So this judgment is a significant development in the law relating to PMLA, in the sense that in many places, when a special court used to issue summons to the accused, they were taken into custody by the special court on appearance. This led many such accused persons to file for anticipatory bail, in which event the question of applicability of section 45 or the twin conditions of section 45 naturally arose for consideration. And in fact, this was stated in Vijay Madan Lal Chaudhary, a three-judge bench, that any person apprehending arrest under PMLA can seek the remedy of anticipatory bail, but they will have to satisfy the twin test of section 45. So in this case, in Tarsem Lal, Supreme Court clarified that when an accused appears on summons, he need not be taken into custody. Even when an warrant is issued and an application is filed for cancellation of the warrant, the special court is not dealing with an application for bail, and therefore section 45 PMLA would have no application in such cases. Now, Senthil Balaji's case, Senthil Balaji came again back to the Supreme Court. This is a Senthil Balaji 2. He is a minister in Tamil Nadu. We need not go into the merits of the case, whether he is really involved in money laundering, etc. We are only concerned with the fair procedure here. Supreme Court observed, and these are significant observations of the Supreme Court, that expeditious disposal of trial is warranted in cases where the statutes lay down a higher threshold for grant of bail. Inordinate delay in the conclusion of trial and higher threshold for grant of bail cannot go together. The stringent provisions regarding grant of bail as laid down in section 45 PMLA cannot become a tool that can be used to incarcerate an accused without trial for an unreasonably long time. Sounding a note of caution, the bench observed that constitutional courts cannot allow provisions like section 45 to become instruments in the hands of the prosecuting agency to continue incarceration for a long time when there is no possibility of the trial concluding within a reasonable period. If the constitutional courts do not exercise their jurisdiction, the rights of the under trials under Article 21 will be defeated. And the next step, the court observed, and this is very significant, that someday the Constitution, these are words of Justice Oak, the constitutional courts will have to take a call on award of compensation when after long incarceration, an accused gets a clean acquittal. In such a case, it may amount to violation of his rights under Article 21. Friends, when I was in Telangana, one of the cases handled by my bench was Bharati Cement versus Directorate of Enforcement. The question in that case was whether trial before the special court under PMLA and a trial for the scheduled offence should proceed simultaneously, or whether the trial under PMLA can proceed as a standalone offence. In that context, it was held by the Telangana High Court that though the trial relating to the offence of money laundering can proceed independent of the trial for the scheduled offence, nonetheless, the outcome of the trial for the scheduled offence would have a definite bearing on the outcome of the trial for the offence of money laundering. It would be in the interest of justice that the special court trying the offence of money laundering should await the ultimate decision of the trial for the scheduled offence. Otherwise, it may lead to a paradoxical situation. It may so happen that later on, the concerned person is acquitted of the scheduled offence while convicted of the offence of money laundering under PMLA at an earlier point of time. This would not only be paradoxical, but contrary to the well-established tenets of law as well. ED had filed a special petition before the Supreme Court, but in the course of the hearing, they had, considering the view taken by the bench, they had withdrawn the SLP. So this judgment as of today stands. Friends, you may be wondering as to why so much of emphasis is being given to bail. After all, PMLA is a very, it's a potent weapon to combat the menace of money laundering, which has got international ramifications beyond our borders. So why are we talking so much of bail? Data from the Ministry of Finance, Government of India, reveals a sharp rise in cases registered under PMLA. There were only 209 cases in 2014. And by 2024, ED had registered over 5,200 cases, a quantum jump. However, the conviction rate has remained abysmally low, with only 40 convictions secured by 2023. 5,200 cases registered, 40 convictions. Maximum penalty under PMLA is 7 years. There is considerable delay in conclusion of investigation and filing of complaint under Section 44 of PMLA. With large number of witnesses and exhibits, naturally the trial will take a long time to conclude. When the conviction rate is so low, a person accused of money laundering under the PMLA cannot be kept behind bars for an indefinite period when there is every likelihood, going by the statistics, of such person being finally acquitted in the trial. Therefore, Supreme Court in recent time has repeatedly emphasized on the salutary principle of bail is the norm, jail is the exception. In the second Santil Balaji case, which I had just now referred, Supreme Court has even cautioned about award of compensation when an accused gets a clean acquittal at the end of a long period of incarceration. Certainly, the process cannot be allowed to become the punishment. There is a popular misconception amongst the public equating grant of bail to acquittal. Well, the jurisprudence of bail that has evolved in this country is an expression or a sign of a matured criminal justice system, which is just, fair, human, and proportionate. We don't act with a sense of vengeance. We act with proportionality. We exercise our jurisdiction in a reasoned and in a measured way, Therefore, according to me, the focus should be on proper investigation and effective prosecution. And till the conviction rate improves, people will remain skeptical about arrest, about registration of ECIRs or arrest by the Enforcement Directorate under the PMLA. It was pointed out by my previous speakers that ED officials used to interrogate the accused persons for long hours, spilling over into the night. This has been frowned upon by Bombay High Court also, as well as by the Punjab and Haryana High Court. Of course, the message is gone. They have taken remedial measures. I think it was in October when Kailash Satyarthi, the child rights activist, I know him from a long time before. Since 2010, I have known him. He came to my house and he said, "The judge, I am planning to have a roundtable conference in Delhi of judges to bring in compassion into the criminal justice system." Our criminal justice system should be seen to be humane, with a tinge of compassion. I said, I will definitely, since you have invited me, I'll definitely go. So I went and attended that roundtable conference. There were 10 Supreme Court judges. There were retired judges also. We discussed very many things. In that, when my turn came, I said that we have completed 75 years of our republic. 75 years is a significant milestone in any republic. And our constitution has stood the test of time. But we also need to introspect. Whether somewhere down the line we have strayed here and there, we have made aberrations or not. No system is perfect. Our system also can't claim to be perfect. But nonetheless, the system has worked and worked well. But it is not enough to keep on patting ourselves on the back and saying, ours is the most powerful court in the world. We have done this, we have done that. Certainly we have done many things, but we need to do more. And unless we introspect, the requisite course correction will not come. So therefore, as lawyers and as judges, we need to ask ourselves constantly, and that should be the everyday struggle, whether we have stuck to the spirit of the Constitution. If not, whether we can improve it when we argue the next case or when we deliver the next judgment. No judgment is perfect. No judge is perfect. I always say that a perfect judgment is yet to be written. Look at Keshavananda Bharati. It is hailed as India's greatest constitutional case. There were 9 opinions. Fali Nariman, in his book, he refers to this. He says they're high on content, but difficult to find out the ratio. So ultimately the ratio was what was written on a piece of paper by Justice Khanna, circulated, 9 judges signed out of 13, and that became the ratio in Keshavananda, and this is India's biggest constitutional case. So the point is, I'm not going to that every case is a stepping stone for the next case. Every judgment is a stepping stone for a next judgment. And that's how the law evolves. The law on PMLA is no different. It is evolving. Last time when we met a year ago, we were still discussing many things. Today, we have crossed many a milepost. But this is an ongoing journey. And I'm sure by the time we meet next, for the next edition of the book, the law will undergo furthermore evolution, furthermore changes, necessitating a fresh edition of the book. So my best wishes to the author, Mr. Dubey, who has done a commendable work. My thanks to the publishers for standing by Dubey in this publication. And I hope this edition will be as successful, if not more, than the previous one. Thank you very much, and God bless.
Thank you, Your Lordship, for an enlightening speech, as always. I invite Mr. Akhilesh Dubey, the author of the book, for the vote of thanks for today's afternoon.
Good afternoon, Honorable Justice Mr. Bhuyan, Honorable Justice Mr. Alok, Aradhe, the Chief Justice of the Bombay High Court, Honorable Justice Mrs. Revati, Mohite, Dere, Honorable Justice Mr. Sonak, and Honorable Advocate General who are present on the dais, and the Honorable Justice who have joined us for today's event. My lords, believe me when I say that writing 2 volumes of this book was not a daunting task as it is for giving a thank you speech before this audience who is esteemed an intellectual gathering. As a lawyer, the largest audience I have addressed is typically 2 with the gathering behind my back. Today the situation is entirely reversed and I must candidly admit that I am a bit nervous. So let me begin with apology first for any inadvertent slip-ups that may occur, and it will occur considering the nervousness which I am in, and secondly for dragging you all here on a lazy Sunday afternoon. But after hearing the enlightening discourses by the dignitaries present on the stage, I think that I may be absolved of that crime for dragging everyone on a lazy Sunday afternoon. Before I begin with my thank you note, I would like to address a few points as to why this second edition was necessary. As we are aware that the Article 21 of the Constitution of India and the 5th Amendment of the American Constitution protect life and liberty as inviolable rights. However, there is a stark difference between the both. The American Constitution uses the term due process, whereas our Constitution uses the term procedure established by law. And I will explain why the stark difference has led to the second edition of this book. When this article was being drafted, it was earlier Article 21. In the draft Constitution, it was Article 15. When it was being drafted, the Constitution Assembly members were grappled with the problem for balancing individual rights against the concerns of the judicial overreach. Constitution Assembly members were divided on whether the term procedure established by law should be replaced with due process. And there were plausible reasons behind this debate, as some members argued that the term procedure established by law would allow the legislature to pass laws which violated individual civil liberties. They suggested if the term due process was adopted, instead, judiciary would always have the right to protect these liberties by investigating whether the law was consistent with the other fundamental rights. But at that point of time also, like today, some of the members of the Constituent Assembly argued that the due process allowed the unelected judges, who themselves are not immune from prejudice, to undermine the authority of the legislature by passing judgments on lawfully enacted legislations. The advisory committee at that point of time on fundamental rights initially recommended due process, guarantees for life and liberty. However, the drafting committee led by great liberal Dr. B.R. Ambedkar replaced this with the phrase procedure established by law in the final draft, which we find in form of Article 21, which reads as, no person shall be deprived of his life or personal liberty except according to the procedure established by law. This was first interpreted by the Honorable Supreme Court, as we are all aware, in A.K. Gopalan versus State of Madras, wherein the Honorable Supreme Court interpreted that the Article 21 of the Constitution did not require Indian courts to apply standard of due process of law. The Supreme Court also interpreted that Article 21 only guaranteed procedural fairness, not substantive rights, and further held that rights under Article 14, 19, and 21 were treated as mutually exclusive. However, after 28 years, the first time when the Honorable Supreme Court revisited this issue elaborately, in Menka Gandhi versus Union of India, the Supreme Court expanded Article 21 beyond mere procedural compliance to ensure that laws governing life and liberty adhere to the constitutional principles of fairness and non-arbitrariness. The constituent assemblies, in my opinion, the decision to exclude the phrase due process of law and adopt procedure established by law in Article 21 to curb judicial interference in the legislative matters inadvertently laid the foundation for transformative judicial intervention. Over time, the constitutional courts interpreted the term procedure established by law to include elements of fairness, justice, reasonableness, effectively introducing substantive due process into Indian jurisprudence. This shift in judicial interpretation illustrates how the Indian judiciary has historically acted to safeguard the civil liberties against executive overreach, while simultaneously maintaining a balance with the state powers, and further demonstrate as how the judiciary serves as the backbone of the Constitution, providing the structural support on which it stands. As Justice Bhuyan in his address said, that the system has worked well. As lawyers, we can affirm this statement. In recent times, there has been no provision of law which has evolved at which the provisions of PMLA have evolved. At the time when it was argued that PMLA was draconian, the Supreme Court again intervened, expanded the scope of fundamental rights vis-à-vis provisions of PMLA. It took 28 years from A.K. Gopalan to reach to the interpretation of in Menka Gandhi, but only 2 years to interpret the provisions of PMLA and apply the principles of Article 21 to the provisions. The judgments have been already discussed, but 2 judgments I would like to address here. In Pravir Purkayast and Manish Sisodia, the Honorable Supreme Court relaxed the twin condition bail, which is under Section 45, by emphasizing that the prolonged incarceration without trial justified bail as speedy trial is fundamental right within the broad scope of Article 21 of the Constitution. We are privileged to share the dais today with esteemed judges who have played a pivotal role in delivering such landmark judgments that have safeguarded individual rights while upholding the rights of the state through their interpretation of Article 21 of the Constitution. Instead of delving further into evolving interpretation of Article 21, I encourage the law students who are present here to explore an insightful interaction by the Honorable Chief Justice available on the YouTube under the title Changing Dynamics of Article 21 by Honorable Justice Mr. Alok Aradhe. Justice Bhuyan's contribution to the recent evolution of PMLA jurisprudence are truly exemplary, reflecting his deep commitment to upholding constitutional values while ensuring the fair application of the law. His insightful judgments and nuanced interpretations have significantly shaped the legal landscape surrounding the PMLA, striking a balance between combating financial crimes and safeguarding individual rights. My friend Vagish Mishra, whom I am thankful for comparing this show, and also Honorable Justice Mrs. Dere, referred to a remarkable judgment delivered by Honorable Mrs. Justice Revati Mohite Dere in the case of Ram Kotumal Asrani versus Directorate of Enforcement. This case is also a classic example where the scope of Article 21 to include right to sleep as an integral part of the right to life and personal liberty has been interpreted. This decision not only reaffirmed the sanctity of human dignity, but also set a significant precedent in ensuring humane treatment during legal proceedings, which has been taken, as rightly said by Honorable Justice Mrs. Dere, by the Enforcement Directorate by publishing a notification as to what should be the timings of conducting the investigation under Section 50 of the PMLA. However, there are still a lot of grey areas which needs to be addressed, and I hope this will be addressed in coming time. Thank you, Your Lordships and Ladyship, for gracing this occasion with your insightful words. It is truly a profound honor and privilege for humble students of law like us to share this esteemed dais with such distinguished luminaries of the judiciary. I would also like to thank Mrs. Sanghmitra Das Bhuyan for being present today. The word thank you feels far too inadequate to convey the depth of my gratitude toward the honorable judges, senior counsels, advocates, students, and my dear friends who have gathered here today. Your presence graces this occasion in a way that words alone cannot capture. Coming from a humble background, I am deeply aware that I may never be able to truly repay the kindness and honor of your presence. However, please know that these words, though simple, are heartfelt and brimming with genuine appreciation and gratitude. I extend my heartfelt gratitude to Honorable Justice Mr. M.S. Karnik, whose gracious contribution made this book a reality. Despite not knowing me personally, he generously agreed to pen the introduction solely on the merit of the manuscript and his belief that this work deserves to reach a wider audience. His continuous support and encouragement has been instrumental in bringing this book to life and would not have been possible without him. Thank you, sir, for your contribution to the book. Honorable Justice Mr. B.R. Gavai has graciously honored this book with his foreword not once but twice, a gesture which is both profound reward and a source of immense encouragement for future writing endeavors. I extend my deepest gratitude to Honorable Justice Gavai, whose unwavering kindness and support towards students of law like me serves as a beacon of inspiration and motivation. I am truly blessed to have guidance and support of many esteemed seniors who treat me as a friend and generously offer their valuable advice whenever needed. I am deeply honored by the presence of retired Justice Mr. B.H. Maglapalle, who had taken an early morning flight from Delhi to be present here to bless me. I am equally grateful to Mr. Abhay Kashyap, co-author of the Commentary of Constitution of India with his father, the legendary Mr. Subhas Kashyap, who also came in the morning just to bless me. And my friends Amit Gupta and Raj Sampath. My heartfelt thanks also go to the senior counsel, Mr. Atul Rajadeksh, who instilled in me the importance of rigorous research, and senior counsel, Mr. Narendra Valavalkar, a father figure whose unwavering support and kindness means a world to me. I also thank Mr. Vaibhav Joglekar, Mr. Asutosh Kumbhoni for being present here and always supporting me in my writing endeavors. I am profoundly thankful to each one of you for your encouragement, and also to my seniors, Mrs. and Mr. Arun Tripathi, and also my parents who made this possible despite not being very privileged. They invested in my education. Lastly, I wish to express my heartfelt gratitude to my colleagues, dear friends, Mr. Suresh Sabrat, Secretary of AAWI, Mr. Relekar, President of AAWI, Mr. Rui Roderick, Senior Advocate. Their unwavering support and contribution has been instrumental in making this endeavor possible. I am truly fortunate to have such a remarkable individuals by my side. Thank you so much. Thank you for being here. Thank you.
Last but not the least, I would like to invite Mr. Ravi Puliani of Bharat Law House to speak few words on this occasion.
I, on behalf of Bharat Law House Private Limited and Mr. Akhilesh Dubey, of course, he's given his vote of thanks. Thank the honorable guest, chief guest, Justice Ujjal Bhuyan, the guest of honor, Justice Alok Aradhe, the special invitees, distinguished guests on the dais and off the dais, and learned professionals present here on a Sunday evening for this event. It has been a great learning experience for all of us to know a little more on this subject that we read and hear every day. There are a lot of professionals in this gathering. I am sure many of you cherish the thought of writing a book. With my decades of experience, and I hope Akhilesh Ji will agree with me, writing a book is not easy, but it is not difficult either. Everyone present here in this auditorium can author a book. It requires a tremendous sense of satisfaction and accomplishment, sharing your thoughts with the fellow professionals. It requires a lot of determination and time management. Today, when you reach home, decide on a subject of interest to you, discuss with the publisher, feel free to call me if you like, and set a reasonable deadline to complete the book. It is possible, and you can do it. Before I wrap up, I must also thank the Master of Ceremonies, Advocate Vagesh Mishra, for having anchored the program in an excellent manner. Last but not the least, and here Uttam enters, I would like to thank Ujjal Bhuyan, who supported us all through in organizing this event in Mumbai. Thank you very much from the core of my heart. Thank you, everybody.
Thank you, everyone, and thank you to our honorable judges of the Bombay High Court who all are present here today. With this, we end with this session, and I hereby request all the guests to join us for the lunch, and our volunteers will guide you. Thank you so much.